So I let the floor to you, Ricardo. Welcome.
So good morning, everyone. My name is Ricardo Gomes. I am a senior associate with a law firm in Finland called Dittmar and Indrenius, who is organizing this webinar in partnership with FIPS. The topic today is climate change mitigation, risk mitigation. And it is my pleasure to introduce Annette Magnusson. I am very happy that she accepted this invitation, and already thank you for that. If I may say a few words about Annette, she was with the Arbitration Institute of the Stockholm Chamber of Commerce for the past 11 years. The SCC, the Stockholm Chamber of Commerce, or the institute, the Arbitration Institute, administers disputes and is the leading institution in Sweden. So Annette has seen her fair share of disputes over these 11 years. On a personal note, Annette has been an inspiring role model for younger generation of dispute resolution lawyers like myself, due to her career and the initiatives that she has promoted and even started. I recall in recent years the edition of a book called Arbitration for Peace, or Arbitrating for Peace, which she was one of the editors of, and it says enough that the preface of that book was written by Kofi Annan, the previous or one of the previous UN Secretary Generals and a Nobel Peace Laureate. More recently, Annette started, she's a co-founder of Climate Change Counsel. The name might be suggestive, but I would like to hear more about what they do and actually why did Annette co-founded this firm. So Annette, if you could say a few words of what is Climate Change Counsel and why did you found it?
Thank you, Ricardo. Thank you so much for your kind words, and good morning, everyone. It's a pleasure to be joining here for this webinar today. So as you mentioned, I have been working at the Arbitration Institute of the Stockholm Chamber of Commerce for many years, and in that capacity, I had the privilege of being able to focus on the policy side of dispute resolution, and of course, the Arbitrating for Peace and the SEC Centennial and everything surrounding that was part of that mission. But it was difficult to work in an international law sphere and not pay attention to climate change. So quite a substantial part of our policy work involved climate change issues, and particularly under international law, but also in other areas, and how arbitration, for example, can contribute. And I suppose I just came to the conclusion that rather than having a part of my daily work be focusing on this important topic, I decided to go full-time for climate change and the law. And so that was the thinking behind Climate Change Counsel. And it's really, I suppose the name is just being counsel for climate change efforts in whichever capacity that is possible and where that is needed. So that's sort of my background. So I was curious, Ricardo, your background in climate change issues. I mean, it's very nice of you to invite me here today. So when did your eyes open, so to speak? What spurred your interest in this very important area?
Thank you. My first comment is that to have the title of Climate Change Counsel sounds pretty cool. So thumbs up for the name. My interest is a little bit more personal. I have recently lived in Mexico City, and having traveled from the Nordic paradise called Finland, where nature is so accessible to everyone, and pollution and air pollution is not on our daily minds, perhaps, or it's not visible with the naked eye. When I was there with my family, and especially our 1-year-old at that stage, and you had to daily monitor the air pollution in Mexico City in order to figure out whether you could go out or open the windows of your home. It kind of made me realize that as lawyers, but also as persons, we have a responsibility, and it's up to each one of us to take that responsibility and use the tools you have in your professional life to also make an impact. So when I returned here, Dittmar was kind enough to be of the same mind and kind of gave me also the tools to study more on this and also be involved in this in Finland and in the Nordics. So that is the background. And since then, we have advised clients on these issues and also held these kinds of webinars to promote discussion in Finland. And I guess that's what we will do today here as well, or at least that's our goal. I would be happy if we manage to do that. So if we proceed to what we have on the agenda today, we will actually start talking about getting involved and talking about these issues openly in Finland and in the Nordics. Annette will give her background in Stockholm, and I will also tell about my personal experience on getting involved. And then we will go into more of the substance. I noticed that from the participants list, many of you are not lawyers, so we promise to address our complicated legalese vocabulary and try to make this as pleasant as possible for you. We welcome questions or comments or clarifications in the chat, so please use it. I know that in Finland the threshold is high, but we would definitely encourage you to ask questions. We will try to answer to the question, what is a climate change dispute? Present some of the recent case law that has been coming up, mostly from Europe, but there's a huge movement also in the US, for example, and elsewhere in Asia. And then we will comment on the last judgment, the Royal Dutch Shell judgment that came out in May, and try to give some pointers on why it matters for Nordic companies to take a look at that. So if I may ask Annette to paint us the broad picture of what's been happening and how law can play a role in this field.
Well, thanks. So I think it is quite inspiring, or very inspiring, how we are seeing how the law is being added to the toolbox, so to speak, in terms of achieving progress for climate change adaptation and mitigation efforts. And I think what we will be talking about here today is really a very strong illustration of that, and that is the case law that is being developed across the world in this area, the climate change cases. But there are other ways in which the law can serve as an accelerator, and this is just sort of the way we are working at this at the Climate Change Council. And I also know that a number of the law firms, including Ricardo's law firm Dittmar, is doing it, is sort of assisting public and private actors in, again, utilizing the law as an accelerator in their action. So one way of doing that is really to go deep dives. So that's what I mean by that, is to really trying to understand the research and analysis involving climate change from a legal perspective. And how do the changes, for example, in climate change law around the world affect a particular organization or a particular sector? These are issues that could be important to drill deeper into. And what are the risks, but most importantly, what are the opportunities from these new climate change legislations that we are seeing increasing enormously across the world? So that's one way of using the law as an accelerator in the deep dives. A second one, of course, is in that injunction between climate and business. So how do you make sure that your organization's climate commitments is really embedded in your legal fabric of your organization? And Ricardo will come back to that, I think, throughout the presentation in terms of giving some examples how that can happen, how you embed your climate change ambitions and actually make them into obligations. And here there's a lot of opportunity for research and analysis that can be done in collaboration with the lawyer in the legal sector. For example, the law firms and the in-house legal departments, but also other experts, to really see where you can have 1 + 1 = 3 when it comes to climate and business. And third, I think it's really important that we have a discussion on capacity building at the executive level in all corporations. So really that the executive perspective should include the climate change perspective. We see that is happening to a higher and higher extent, but I do believe there is still work to be done here. So talking about executive training, talking about training your board members, having board members understand their responsibilities, their duties, and their expectations when it comes to climate change related issues. That's another area where the law can really be a strong accelerator for climate change action. And last but not least, and this is where this illustration from this slide is sort of alluding to, is really, and this is where we at Climate Change Council see an important role for us, or an important mission for us, and that is really to mobilizing the legal sector at large, to work with the law firms, to work with the in-house law departments, and really doing webinars like this, and putting that climate change awareness brick in the brain, as we like to call it, all throughout the operations of the company. That's and having the law firms and the lawyers contribute to that development and that progress. So I think that's really an important area going forward. So I think I'm done there, Ricardo.
Thank you. I think this is an obvious point, but the call on the Nordics has been set to the highest levels. So we started with a quote here from the UN's current Secretary General on the responsibility of the Nordic countries, and now traditionally Nordic countries have led the way. Having said that, there is of course a lot of room for improvement and development, and there are areas where the Nordic countries are clearly behind. I feel a little bit awkward talking about the IPCC report to sustainability experts. You probably know all about it, but we still included it here as a reminder that we are talking about a scientific field as much as a legal field and as a business field. This slide goes into what Annette was saying about involving the community. What I noticed when I returned and started looking into more these issues of sustainability and climate change is that this is probably becoming an issue because general counsels and legal counsels of companies know legislation by name and even can drop some dates of those legislations. So when that happens, it means this has been discussed in the organization and it's probably getting some importance. So I was checking the evolution of the use of the word sustainable, sustainability, and climate change throughout time in books. So this is an engram that shows how exponential the growth has been. And the proof of that is that virtually today, every organization has a sustainability manager or a sustainability officer, and legal counsel is supporting that sustainability officer and vice versa. On getting involved, I've been personally involved in this project called the Chancery Lane Project. It is perhaps a more UK focused project, but it really gathers participants from all over Europe. You can see the numbers on the right. But what I wanted to say about this is that this is a collaborative effort of lawyers from all over the world, mostly UK and Europe, whose vision is to draft clauses or certain toolkits that legal counsels and organizations can use in their day-to-day work. So this organization develops model clauses or model definitions that can be used in the day work of organizations. They also develop contract playbooks or net zero toolkits, and they launch impact reports. These are all available online if you Google the Chancery Lane Project. The latest of these kits was the Net Zero Toolkit, launched a couple of days ago, and it includes net zero aligned clauses in their contracts so that they can just be adapted to your organization. From the Nordic perspective, what I wanted to say about this project is that the clauses are UK focused, but they can definitely be used in the Nordic sphere. So for example, one clause that I can say from the top of my mind is a termination clause for a greener supplier. So you have a supplier, but then you found in the market that there is a supplier supplying virtually the same goods, but that's a greener option. If you have this termination for a greener supplier in a contract, then you would be entitled to terminate that contract and shift to the greener supplier if your own supplier cannot provide you with the greener option. These types of clauses, this is one example of the 1,000 plus clauses that there are in this database that can be used directly into our Nordic sphere. And this is the end of the examples of how you can get involved. And now we get into perhaps more of the substance and the topic of today. Climate change cases is a very broad concept. So because we have a specialist here, I will leave the difficult questions for Annette. Maybe Annette can tell us, what is a climate change case?
Thank you, Ricardo. And yes, let's talk about what the climate change case really is. I think when we talk about climate change litigation and climate change cases, it's, in particular with this audience, it's important sort of to do that from a corporate perspective standpoint. So I will give a brief overview, sort of what's from that perspective of climate change litigation. And then I think we will dive into some of the details, so some of the very relevant details when it comes to recent cases, but that I think all corporates really should be aware of or pay attention to. But to start out, I think it is important really to, and maybe that is stating the obvious, because since you are here, might be aware of this already, that a climate change litigation is really growing very fast. And we have seen more close to 2,000 cases identified so far around the world. So, for example, if you look at available statistics, we have seen that the case is more than double between 2017 and 2020. And what is a really interesting number from one of the reports that I was reading is that we have seen more than 1,000 cases being brought in the last 6 years. So that tells you something about how fast this area is growing. Now, most climate-related cases so far have been filed by citizens or civil society organizations, NGO, against governments. But there's a trend, and this is why, again, why we're here today, is that there's a trend that climate change litigation against companies is on the increase. So far we have seen about 10% of the total number of cases directed against companies, but that is expected to increase going forward. So this is why it's so important for companies to understand this sphere of litigation and why that could matter for your corporation. And that is really regardless of your industry and regardless of your geography. This is a global issue. So then, to the point of what is the climate change dispute, there are many ways in which to put a label on a case and say that this is climate change related. Climate change could be like a central argument of the case, where the case is really argued around the Paris Agreement and central legislation that really is essential for climate change law in general. So that's sort of a large number of these cases are where the climate change issue is really central. And then you have the cases where climate change is sort of it's related to the issue at hand, but it could be, sometimes it's called as incidental or peripheral. So it has consequences for climate change adaptation and mitigation efforts, but it's not central to the case. So I think what we will be focused on here today is really the cases where climate change adaptation and mitigation efforts are central to the case, where litigants rely on specifics, sort of climate change facts or law to argue their case for adaptation and mitigation efforts. So that's what we were talking about here today. But again, when you put the label climate change related disputes, it could be much larger than that. So then a few words then on what corporates need to be aware of in this area. So like I said, that most climate change related cases so far have been filed against governments by citizens or NGOs or civil society at large. And usually, or many times, these cases concern issues like keeping the fossil fuel in the ground, or they are challenging the non-enforcement of climate-related laws and policies, and it's being argued that things are happening too slow, or that not enough is being done. So that's one large of cases. But if you're looking at the cases against companies, and against, like I said, this is an area which is growing, you could see that the cases against companies are mainly falling into two categories. The first category is where the cases where it seeks to hold corporates accountable for past conduct and the potential harm that has been caused by the corporates. But the second category are cases that really seeks to influence the company's future conduct by demanding more ambitious climate action and greater transparency. And here, of course, we have some interesting examples only from this year. So these cases, they challenge the corporate's conduct, you could say, And they challenge the conduct of the corporates by reference, for example, to human rights obligations in addition to climate change obligations. And they challenge that in relation to disclosure requirements. And I think this is an area which will also grow going forward, where the requirements for transparency and really reporting and being able to back up the reporting with concrete action will be of increasing importance for corporates. So we will probably see a development going forward where cases against private parties, against companies, again, is probably going to increase. And also the content of these cases is probably going to develop as we move forward. So this relates to the arguments that are being forwarded against corporates, and the strategies against corporates will continue to develop. And there is tendency that there is more diversity in the arguments being used against corporates. And we have seen tendencies of this. So we have seen, for example, themes of greenwashing, and we have seen themes of fiduciary duties relating to corporates. So that is something we can probably see more of. We have seen that insufficient communication relating to climate change will be a risk for corporates. And really there needs to be, again, a strong infrastructure and the actions within the corporation that really are able to back up any statements that are being made when it comes to climate change ambitions from the corporate side. So this is really, when it comes to the financial risks and fiduciary duties, this is something that is probably going to increase also going forward. That's an area we might be seeing more cases in. And again, this means that the climate change litigation is not an issue only for fossil fuel companies. This is something that for all companies across the scale, regardless of industry, regardless of geography, this is something that anyone involved in a large business really needs to pay attention to and be aware of, and do their homework in terms of risk mitigation. And when it comes to risk mitigation, another area where corporates really need to pay attention is that they need to communicate and take action to meet these risks, not only when it comes to sort of litigation risk, but actually they need to, as part of that package, be able to demonstrate that they have understood and take action against the physical risks caused by climate change and the transition risks. For example, we talk about stranded assets. Again, these are measures that companies are expected to take. So failure of understanding the risks associated with climate change could mean responsibility for directors or for officers of the corporate. So it's a complex picture, but I think there's much to learn from previous cases in this area. And like I said, I do think that we can see these cases will continue in the future. And I think we will talk a little bit more about the future further on. So I think I will stop there, and then I'll leave to Ricardo to go into some of the more of the details of this.
Thank you, Annette, for the broad picture. As Annette said, defining a climate change dispute is really complicated. We will focus today on the, let's say, purely climate change mitigation and adaptation cases, but the cases can take different settings. And I tried to illustrate here the settings that they may be. They may be based on a contract, they may be based on a treaty or a national legislation. They may be based on an authority imposing an obligation on one party or the other, a fine or a compliance matter. So the intricacies of climate change dispute is really big. The difficult part now for a lawyer is to explain a legal background without being too legalese. I'll try my best. So when a party brings a climate change case, they will typically argue their case on the basis of a treaty, a law, a directive, or a convention. So that means that party A will come to the court or to the arbitral tribunal and say, I'm asking you to do X based on these treaty obligations or based on the choices that this corporate has made on being committed to climate neutral or UN guiding principles. So with the examples that we have seen coming from throughout the world, these have been some of the typical legal background that the parties have argued. So parties have said, I have this, I'm requesting this country to reduce their CO2 emissions based on the obligations set out in the Paris Agreement, which this country is part of, or the UN FCC framework. Interestingly, as Annette said already, human rights are coming as well as one of the arguments used by parties, and the European Convention on Human Rights specifically has been argued in the landmark case that we will talk about later on. And if you think about it, the European Convention on Human Rights is an instrument that was approved in the 1950s or in 1950. So we are now using it for climate change disputes in 2021. But also national laws in Finland. This is the Finnish perspective. There is actually in the Finnish constitution right to environment and biodiversity, Article 20 of the Finnish constitution. The Finnish Climate Change Act is now under reform, but we know already that it's not going to impose really obligations on companies or on the private sector. It's going to be mostly for the public sector. However, interesting things are happening on EU level. There's a lot of initiatives, and of course, since 2019, the EU Green Deal and the Fit for 55 packages that came now last summer, but also interesting corporate sustainability and corporate governance initiatives. I think one of the last FIPS webinar in partnership with Dittmar was actually about this topic. So I have a reference later on, but most of this we already heard from my colleagues. I think it was Kaisa Päivinen and Krista Poitsalo. And then last but not least, there is also some international treaties, such as the Energy Charter Treaty, which is also being used by companies when they argue their cases against states. And there is a case that has a Finnish connection with Uniper in arbitration that I will touch upon later. The slide's not changing now. This slide was just to illustrate what was happening. I think for the Nordics, the land use and the LULUCF revision is something that is getting some attention, at least here in Finland. But depending on the business area you are in, there's a lot of trains moving at the same time through the European legislation. Just like Annette mentioned, in terms of corporate reporting, this is an interesting thing that came up in the Corporate Sustainability Reporting Directive proposal. And in the Q&A published on the Commission's website, there was this reply to a question, and I would like to highlight the last paragraph. There is ample evidence that the information that companies report is not sufficient. So this is something that it's going to come up. Reporting on what companies are doing in terms of climate is going to increase, and the requirements are going to probably be higher in the future. As you probably noticed, climate change litigation or climate change cases have been in the news in Finland and a little bit all over the world. These are some of the main headings collected over the last year. And just as Annette said, the number of cases almost doubled from 2017 to 2021, and the number of countries as well is quite impressive. But if we focus now on the actual cases that have come up and that have found a resolution in order to find some guidance. And the reason why lawyers tend to present cases that have been decided is that our profession is very much looking at what was happening in the past and what has happened in the past, and try to predict the future and adapt this to your own jurisdiction if the case is from abroad. This is the case. So in this concrete scenario, this is the landmark case that was ultimately decided in 2019. The case was brought by the Urgenda Foundation against the government of the Netherlands. And what Urgenda Foundation was asking was for the court to declare a 25 to 45 reduction in the greenhouse gas emissions from 1990 levels before 2020 in order to keep global warming below 2%. So in layman terms, Urgenda was asking the court to tell the Dutch government, do your part, do what you must in order to guarantee that the Netherlands' CO2 emissions will be reduced. When the case was filed, quite honestly, no one in the world was really thinking that the case is going to succeed. But surprisingly, the District Court of The Hague in 2015 decided, mostly based on tort law, so Dutch law, national law, that Urgenda was right and the government of the Netherlands must reduce their emissions by 25%. This was a surprise, but everyone said, well, but this is District Court. What will the Court of Appeal say? Interestingly, the argumentation changed at this stage, and Urgenda added to their argumentation Article 2, the right to life, and Article 8, right to family life of the European Convention on Human Rights as an extra argument. And the Court of Appeal of The Hague said in 2018, we agree with the District Court, the Dutch government must do its share to reduce the CO2 emissions by 25% by 2020. And everyone once again said, but what will the Supreme Court say? So the Supreme Court in 2019, in December, surprisingly and spectacularly, I would add, said, well, the previous decisions are absolutely right. The Dutch government must do its share and must do its best efforts to reduce the carbon CO2 emissions, carbon dioxide emissions of the Netherlands by 25%. And this is based on a duty of care. So the government has a duty of care for its citizens. The citizens are already affected, and it's very likely that future generations are going to be severely affected. Once again, this was spectacular, but the question was remaining, and that was the million-dollar question. When will a court decide the same for a company? And no one knew at that stage.
Can I just add, Ricardo, because I think it's interesting, perhaps for this audience, that also what is sort of very interesting in this first world famous climate change litigation case is the fact that you are sort of bringing in the UNFCCC, the Climate Change Convention, into a national court proceeding in the national law. So you're sort of arguing that together with the national law. So that combination becomes actually a quite interesting and strong force, as it turns out in this case. And also, just I think it's interesting to note that this first instance decision came out before the Paris Agreement.
Exactly.
Which is also, so now, of course, after the Paris Agreement, we have an additional tool in the toolbox that has been utilized by other courts and other litigants across the world. But this first decision came out before the Paris Agreement. So that's interesting, I find, as well.
Definitely. Thank you for the additions. So if we move on to a next case. So this time, a private citizen bringing a case against an energy company in Germany. The name might not sound German because this is in fact a Peruvian farmer who brought a case against RWE, the electric energy company in Germany, in the courts of Germany, basically for damages of protecting the town and the farms where he lives with his family against floods caused by the melting of glaciers in the Peruvian mountains. And this is a very interesting case in the sense that it's a private citizen, so not a group of citizens bringing the case. And the case was initiated, I think, in 2015 as well. And the first decision came out from the Regional Court of Essen in 2016, and they actually dismissed the case. So the court said, we are not going to hear it. There's no grounds for this case to be brought up. However, in 2017, the regional court, so the Court of Appeal of Hamm, said that perhaps we should hear this case and let's set up an evidentiary hearing. So a place where the Peruvian farmer could bring up evidence. And let me add as well that in the Urgenda case, the case was actually backed by about 40 climate change scientists. So it had a very strong scientific basis as well. And we are currently in this LUA versus RWE. We are currently in the stage that the evidentiary hearing has been scheduled. However, due to COVID restrictions, the court and its experts have not been able to visit the Peruvian city where this is happening in order to assess the damages. So we actually don't know what is the next step, but this is still pending. You probably noticed as well earlier this summer that there was a judgment by the German Constitutional Court. So before we were talking about civil courts in Finnish käräjäoikeus, and now we are talking about constitutional courts. So this is a different route. This is an administrative route that companies and citizens can also take in order to bring up their cases. And when Annette said that there has been some sense that things are happening a little bit slow on this field, this was remarkably fast, I would say, in terms of seeing climate change in action. So an action or a case was filed by German youth in February 2020. And in April 2021, the court, the German Federal Constitutional Court, said that the German government should actually clarify their objectives in order to reach the climate change and climate neutrality goals that it has. So what this caused was that 1 month later, the German government proposes changes to the German law in May 2021. And in the last session of the German parliament, because there were elections just recently, in the last session before the summer, the parliament approved amendments to the Federal Act. So if you think about it, it's in 1 year and 1 month, an action brought by German youth has an impact on organizations because the law is clarified and may change and impose new obligations on companies. Talking about changes in the laws and changing in the actions of governments. An interesting pair of cases is being brought against the Kingdom of the Netherlands. I will skip this slide because they are both of the same, and I will talk about the Uniper case. But this Uniper case is brought up in pair with another case by RWE. And this is not in a state court. This case is brought in arbitration by Uniper, which is partially owned by Fortum, which is partially owned by the Finnish government. So this is an interesting case. So when the Urgenda decision that I just mentioned came out, the Dutch government had a set of possibilities in order to decrease their CO2 emissions. One option on the table was we will have a coal phase out by closing coal power plants by a certain date. And that's what they did. They decided to close some of the coal electricity power plants by a certain date. And Uniper, who had just acquired one of these coal-powered energy plants, brought the case in arbitration against the government of the Netherlands and said that, well, you can't expropriate me of my coal power plant. I have just made an investment that happens to be quite significant. The claim in this case is up to 1 billion, and the RWE is up to 1.4 billion euros. So you can't just change the rules in the middle of the game because of a national case, the Urgenda case, because of the changes in the Climate Act. And actually, my action might be supported by a treaty, by the Energy Charter Treaty, for which the Netherlands is part of. This is an interesting case because it's outside of the court, so we don't really have clear vision. I don't know if Annette wants to comment on the Vattenfall German case, because we might have some similarities here and there, because it was also brought in arbitration. But it remains to be seen what's going to be the position of the Dutch government on this. The Dutch government has replied to these arbitration filings in national court in Germany by saying that these actions are not admissible because when both parties are from EU states, they cannot really bring claims against each other because that's against EU law. That is a bit of a bigger discussion that we could have on another webinar on itself on that. But this is the state where we are regarding RWE and Uniper versus the Netherlands. Annette, did you have a comment on?
Thank you. So I think the comment that I would like to make here is that this case illustrates, as does other cases in this legal framework, the potential, if one could call it, conflict between different ambitions, different policy ambitions. So, and where that ends up will be decided by the facts of the case and the decisions by the tribunal. But you could have, so you would have one policy incentive or ambition would be the attraction and protection of investors, foreign investors, and the certain guarantees that are given to these investors under certain international treaties, so Energy Charter Treaty being one of them, and the other, of course, being the other policy silo, I'm inclined to call it, because it tends to be silos at times, that, and that's, you could have problems when they do not communicate, is the climate change ambitions and the actions by the Dutch government, of course, instilled by the Agenda case in this example. So I think this is an interesting illustration how different areas of international law, not least, needs to be cross-fertilized in a smart manner to get us where we need to be. What we will learn from these cases, it's too early to say because they are just at the outset, but I do think that there are things probably to be learned in terms of how cases are argued, and how just because they have been argued in one way in the past doesn't mean that you necessarily need to do that in future cases to again get us where we need to be in terms of climate change adaptation and mitigation efforts. But this is in a very, very interesting area when it comes to international investment law and the way it works or doesn't work, whichever one looks at it in the examples with international climate change ambitions.
Absolutely. And now if we move on to the Shell judgment, you've probably also seen it in the Finnish news. It was widely advertised in major newspapers and on TV and virtually everywhere in the world, that the first time that company was that these kind of obligations was imposed on a company. So when I told you that after Urgenda, everyone was asking when will it be the first case against a company where this type of commitments are going to be brought up, well, this is the answer. The first case is the case brought by Mildefenseur et al. Against Royal Dutch Shell. The case basically translates into these. The group of citizens asked the court to convict Shell to reduce their emission targets. The interesting part in this case as well is that it not only focused on Shell's own emissions, but actually end users of Shell's products, even though the court was a bit more hesitant on accepting that argumentation. And the sources used by Mildefenseur et al. Were not surprisingly the Urgenda precedent, the Dutch Civil Code, and the European Convention on Human Rights, but also soft law instruments. And this is the interesting perspective that perhaps we want to bring here in this seminar, is that the court specifically talks about soft law instruments that Shell has itself committed to and adopted in their own policies and corporate strategy, like the OECD guidelines or the UN guiding principles on business and human rights, has as an accepted fact So the court even goes as far as saying that these are widely accepted principles. So it doesn't really matter if Shell has committed to these or not, but actually, in fact, Shell has committed to these. So the court in the District Court of The Hague in May 2021 imposed an obligation on the Royal Dutch Shell to reduce their emissions by 45%, which is a substantial amount. And the case is currently being appealed in the Court of Appeals. So we don't know if this decision is going to stand or not. We have been now focusing perhaps on the Netherlands, but the fact is that these types of cases have been seen elsewhere in the UK, in France, in Germany, in Ireland, in Norway, in the Nordics, in Norway with a little bit of a different angle and not successfully brought up. But we have seen these types of cases coming up a little bit everywhere in the world, as well as in the European Court of Human Rights, most recently over the last year, I would say. Annette, probably you wanted to comment on the soft law instruments and
yes, I think you are very right in pointing that out. That's one of the elements in particular that makes the reasoning of the court so interesting here. The reliance on the soft law instruments. I mean, there could be I can of course argue pros and cons whether one should allow the soft law instruments in a case of this magnitude. But regardless, it goes to illustrate the wide acceptance that the climate change challenge narrative has really gained in terms globally, and including with courts today. And the fact that the court to such a large extent talks about the generally held consensus, the global consensus, and it sort of returns to this consensus that they perceive as existing. Which I believe is a good thing in the sense that we have this consensus now that we are in the climate change emergency, and we in whichever capacities we go about doing our daily job, so to speak, that's something we need to be aware of. And so that's sort of an illustration of what the court is doing. So I do think that the application of the soft law instruments is something one should really take note of, and that's also one of the elements of why this decision is one of those cases which I do believe that any global corporation should really, they should study carefully, and they should ask themselves, okay, had this been us, how would we have fared? How would we have fared in this review or that is done by the court here? Because it's not that Shell was doing nothing. They had a lot of corporate action in terms of mitigation efforts, but it just was not enough, or it was not backed up. The statements were not backed up by concrete action in the view of the court. So that's why they ended up where they ended up in the decision. And that's something that's really worth taking note of, regardless, again, what industry you are in, because this expectation applies to all companies today, regardless of the industry. That's why I think this is really an interesting case.
If I may add to these points, that what I found also interesting while reading the judgment is that the court says that this responsibility of the companies in terms of climate change is a positive obligation and not a passive obligation. So it's not enough that companies monitor the climate change developments and how they are doing, but they positively impact on that. They take action, concrete action, and that's a bold move by the court, I would say. But that's something that the court felt comfortable in putting out loud in black and white letters, that just like the respect for human rights is a positive obligation, climate change should also be a positive obligation, I think.
And I think also one could, with a little bit perspective, I think almost it has been appealed, so we don't know what will happen at the next level. But regardless of this, we do know that the discussions that this decision has started and the actions that I'm sure it has instilled in so many different companies that's a good sign. And we know from in the past that the first instance decision from the Agenda case, just the mere fact that the court came to that conclusion, that initiated a lot of positive action for the climate, that in and of itself. So I do think that the mere fact that we have this one instance case, that is good news in terms of we will see change going forward. So we will see what happens in the next instance from a legal perspective.
Ask one question from Annette. I don't know in Sweden, but in Finland we are still lacking as you probably noticed, most of these cases are brought by NGOs or a group of citizens. I mean, in France, one of the landmark or one of the most important cases was brought by, subscribed by 2 million citizens, which would be a huge amount of population for Finland. We are still lacking this class action. So this group of people bringing the claim, or an NGO putting forward that claim on behalf of citizens. How is it in Sweden? Because in Finland that would not be possible. I think the route here would be an administrative court proceeding.
So we haven't seen that there yet. There has been some slight changes in terms of enabling class actions, but that's, to my knowledge, that has not been something that has enabled this type of action. I mean, there have been groups of people coming together and wanting to do, and I should know this, but I haven't seen it recently. What happened to that? So it's still a novel field, so to speak, here as well.
Yeah, it's the same here, and if I may add, an interesting development in March, I think it would be translated in English to the Administrative Court Annual Day, maybe, where the president of the Administrative Court gives a speech and kind of tells what's going to be on the docket for that year, type of prediction. And climate change cases came up there, and his opinion was that the current state of Finnish legislations weaken the possibilities of the court, I would translate, in order to impact climate change and biodiversity. So that's an indication from the president of the Supreme Administrative Court in Finland. So that's interesting. I don't know if there's, I can read it out loud.
Okay, great, thanks.
Do you think that case law can/will strengthen the impact of soft law, such as the UN Global Compact? Annette, if you can go first.
Thank you. I think what we have seen this spring is an example of that actually happening. So it remains to be seen how other courts will reason around the same soft law instruments. But there is an element of where I suppose the combination of the global climate change emergency awareness and the fact that some of these soft law instruments have very strong legitimacy in terms of their buying from including from the corporates and corporations and what they represent. So there is this expectation on following the soft law. So we will see. I do think it is an interesting development potentially happening here.
I also think it's a great opportunity for companies to have that discussion on whether an inclusion of a soft law instrument, whether in their policies or supplier policies or even in contracts, is a boilerplate language type of inclusion, or is it actually something that the company is willing to accept as a commitment? So I think that as far as a court judgment brings up this issue directly and as straightforward as the District Court of The Hague puts it, I think it's a good opportunity for companies to say, well, now we have all included in our website the sentence that we are sustainable and act responsibly and climate change is in our minds. What does that actually mean? Because the court can then go to your webpage and Exhibit A, you have a print screen of the website where it says exactly that you are committed to UN Global Compact, for example, and guiding principles. So that's a great opportunity. I think that's.
And as we are seeing probably going forward that the importance of decarbonization and supply chain in the value chain, climate change issues will be something that potentially courts will be looking into, or that will be challenged in the future, where we have the global soft law instruments that enables speaking the same language, not least throughout your supply chain, to have your partners, your collaborators sign up to the same standards. And I think that's something that could be risk mitigating for you as a corporation if you have that common ground that you're working towards.
You mentioned transitional risks that companies can be challenged if they have not taken them into account sufficiently. Can you open this up a little more?
Sure. So I think I was the one that mentioned the transitional risk. We're talking about sort of the transition into a low carbon society and the industrial transition and the policy transition that is happening as a consequence of this. And so the expectation then being that where corporates have not sufficiently taken this transition into consideration, for example, in planning their long-term plans, and they could be stuck with, for example, stranded assets, that's something that could be they could be held accountable, for example, under the fiduciary duties, where you are you are expected to look to the long-term benefit of a company if you are the director, for example. So that's an example of an element of a transitional risk. You need to sort of take the climate change transition and what that entails for your company into consideration when you plan ahead. And if you have not done so, you have not acted diligently for the sake of your company and potentially for the sake of your shareholders.
I think that's something that we are also seeing in financing of M&A deals. That has at least come up as a consideration, and probably it's going to be even taken up more in the future in due diligence exercises, I would say.
Thank you. Any more questions from the audience? If not, then we probably start wrapping up this webinar. Well, there is still one. What are the strongest legal arguments against corporations in climate change cases? A big question.
This is a big question. I don't know if the question is coming from a Finnish perspective or from what we have seen in the world, but I think that in the presentation we've mentioned quite a few already. The obligations of a company, the Paris Agreement, the United Nations framework comes up, the soft law instruments. I would even add the Paris Agreement and the European Convention on Human Rights is a pretty strong case or a legal argument, and you see it as well in the recent cases filed in the European Court of Human Rights itself. So if these cases tend to go to those kinds of forums, then there is probably a good reason why this is happening. So I know that there's a parallel discussion on whether climate rights are human rights, if even is that a discussion on that. An interesting development as well in the last UN General Assembly, there was the legal opinion, I think from the ICJ at least, on these climate change issues. So that's something that remains to be seen, but that's a broad question. I wish I had the answer with the Finnish case already out of the top of my head.
And maybe a question for another whole another webinar.
Okay. And yeah. If there's questions remaining, feel free to email us, and we would be happy to respond, I would say.
Okay. Thank you so much, Ricardo and Annette. This has been very interesting discussion, and thank you all for all the audience that stayed for overtime with us to discuss and listen to this interesting discussion. So I thank you all, and have a great day ahead.
Thank you
as well.
Yeah.
Okay, bye.
Bye bye.
Bye bye.